Good afternoon, everyone. Welcome to this Protecture webinar on data protection, clearing the haze around the GDPR maze. It's Gary Shipsey, Managing Director. I'll be taking you through this next hour. We're going to look at a high-level overview of the main issues that the General Data Protection Regulation will pose for you as an organisation, and start to give you some key messages to take back to your colleagues, and hopefully some key actions that you can take away today to start preparing for this law that is coming in May 2018. A bit of housekeeping before we start. There are a couple of audio options that you've got either through your computer or accessed via your telephone with the PIN codes that were shown at the start of this webinar, and I think everyone seems to be on board with that. So without much further ado, I will continue into the webinar. We've tried to look at the GDPR in the most practical way possible, and we've split it into four key themes, looking at the Information Commissioner's 12 steps. We are going to start with looking at awareness, accountability and governance. So we're going to look at the role of the data protection officer and your relationship with your suppliers, and starting to plan for the GDPR, especially if you're looking at new systems and procurement now, making sure that they are ready for the system requirements that will have to be in place come May 2018. We'll then look at information management, and this is really all about getting an understanding and real detail on the information that you handle, knowing where it comes from, why it's used and how it's used, where it's stored, who it's shared with, really knowing the nuts and bolts of this really key asset that is your personal information. We'll also then recognise that that data about you is important, because actually individuals' rights and expectations are increased with the GDPR. So if we don't know much about our information, it's very difficult to know whether we should or shouldn't dispose of it if an individual asks. We struggle to find it if an individual makes a request for it, and we need to know what rights individuals have so we can manage expectations and deliver compliance to the individual. And finally, we'll look at information security and risk. That is a key element, and most of the fines that have been issued to date for data protection breaches do relate to information security. So we do need to really understand what the GDPR requires when it comes to this key topic. So let's look at data protection officers. Now, there was a lot of publicity before the final version of the GDPR came into force about whether every organisation would, by law, have to appoint a data protection officer. That didn't actually come through in the final version. Only certain types of organisation have to appoint the data protection officer as defined by the GDPR, and that is public authorities, organisations that carry out large-scale systematic monitoring of individuals such as Google and Facebook, and also organisations that handle lots of medical data or criminal record data. So many organisations will not have to legally appoint a data protection officer. Anyone can do it, and you can appoint a data protection officer a group of organisations if you're working, if you've got a sort of federated arrangement with your charity or your membership body. But the bottom line is, even if you don't appoint a data protection officer as defined by the law, you've got to have the skills and knowledge to actually demonstrate that you're complying with the GDPR. You've got to have an understanding of what the Act requires and what it means to deliver compliance. So it's a critical role to get right. It's useful to look at what the GDPR says that a data protection officer has to do, and a lot of it's common sense about the fact they are the point of contact for your staff, for your volunteers, for external individuals, for the Information Commissioner. They are the point at which people will come to you and expect to know what's going on and how you're delivering compliance. They will have a role to monitor compliance internally, to raise awareness, to inform and advise staff, to have independence in delivering their role, and that's one of the critical things, is to think, okay, well, who, if we're going to use someone internally, will have the right skill set, the right reporting lines to really deliver on the role. The formal data protection officer will have to, by law, report to the highest management level within the organisation and be able to act independently. We'll be able to give, bad or good news to the powers that be without threat of being penalised for doing that. And they must have adequate resources to meet their obligations in ensuring that the organisation is compliant. So the question will be, who's going to deliver this for you? If it's not the formal role, who is going to take this on? Is it going to be Tommy sat in IT? And actually there is a potential conflict of interest because Tommy in IT actually has to then monitor and audit how well IT are delivering compliance. So he might not be quite the right person. He might need to go higher up the structure, management structure. The GDPR says, okay, it depends. You may have someone who's an existing employee if those conflicts aren't there, or you may contract it out externally to an organisation that has the skills and expertise that can deliver the overview, the monitoring, the advice, and be the point of contact when it comes to GDPR. But the main issue is getting someone now to take this role on and start to understand what's required for their organisation and start to deliver the actions to move from the current data protection compliance to what the GDPR will require in May 2018. So that's one of our key recommendations. If you take nothing else away today, it's to start to get that position in place. And we're just interested to put a poll out there if people would be willing to engage with that about, is someone already taking the lead on GDPR? Do you know who that's going to be? Please let us know if someone's already on it, if it's likely to be the existing person that does data protection, or actually you don't have anyone who does even that at the moment. So we're just interested in the feedback you can give us. Please participate in the poll. It would be very interesting to see the figures, and we'll circulate some of that data and the responses later on after the webinar. Okay, thank you very much for all those who voted. That's been really interesting. We will disclose those results after the webinar. So, having defined who's going to lead on this, the other key issue to think about when it comes to accountability is the sort of subtle but quite fundamental shift in how you've got to deliver compliance. So at the moment, we have to all go through this clunky process of notifying and registering with the Information Commissioner. That process will go when the GDPR comes into force. Instead, the emphasis will be far more on you as an organisation maintaining the records of your activities. So being able to prove and demonstrate that you're complying. And the GDPR puts this in black and white for all of us to see. And it literally is spoon feeding us. It's saying we're not only responsible for complying with the principles, we've got to be able to demonstrate how we're complying. And that's common sense, that's what best practice is now, but it's saying that this is literally, you've got to do this. The ICO over the years has been far more sort of standoffish to say, well, as long as you are complying, we're not going to literally tell you that you must have policies and you must have procedures. We'll ask you for that stuff if and when something goes wrong, but we're not going to literally tell you you've got to do it. As long as you're complying and you're happy, that's okay. Well, the GDPR ups the ante somewhat and says, no, you've got to be ready and able and must maintain records of your activities and be able to demonstrate compliance whenever anyone asks. Whether it's the Information Commissioner, whether it's an interested donor, whether it's a newspaper, you've got to be able to quickly say, here's our documentation that shows how we're delivering compliance. So this can be seen in certain bits of the regulation. I put up an example here about security. It's, again, not just being able to ensure that you are compliant, but be able to demonstrate that your information security, your IT, your policies and procedures are in place. And it literally says you may have to you shall be implementing appropriate policies. So it's a good example of where the GDPR takes the best practice and what we'd expect to be in place now and says, no, you really have got to have these records, this proof, this evidence to demonstrate that you're compliant. An area where that can also be seen is your relationship with your suppliers. So at the moment we have a situation where your suppliers, your data processors, have no obligations under the Data Protection Act. They only have to comply with the contract that you have in place with them. Well, the GDPR sort of takes that away, and in some areas says actually there should be a fairer split between the accountability for compliance. It states that the processor as well as the controller shall implement, for example, appropriate security. So it's kind of like what we've got now, but it's, as I sort of described it here, contract plus. It's building on what we've got and actually probably more fairly allocating the accountability for compliance. It will mean that looking at contracts and renewing and updating contracts that you have with suppliers to make sure that they do fairly allocate responsibility for compliance with the GDPR, and that would be very important, especially for some of the larger suppliers that you may work with. Another area of accountability and governance will be the concepts of privacy by design and data protection by design and data protection by default. And again, this is taking what's best practice at the moment and putting it into law. This is the quote from the GDPR, and it's essentially saying that you've got to, at the time of thinking about new means of processing the data, a new database, a new CRM, and once it's up and running, you've got to make sure that it's got appropriate measures in place to implement the principles in an effective manner. What that's a long-winded way of saying is, don't drag the data protection compliance person in just as a project's about to go live and then raise questions and queries about how compliant it is and how efficient and effective it's going to be about managing data protection issues. We've got to have data protection input right at the start of a project, so they can feed in, the data protection concerns they may have, the requirements of the GDPR, so the system is built with those issues in mind, rather than bolted on afterwards or not addressed at all. So it's really making sure that these people, the data protection leads, are in the room when project discussions, process changes, new systems are being considered. Similarly, the data protection by default is saying that actually we must think about making sure systems are doing the right things when it comes to data protection. By that I mean, as the quote says here from Article 25, that it only handles and processes the right information for the right, clear, specific purposes. Whether that's the amount of information it collects, how far it's processed, who can see it, who can access it, how long it's kept for, and who can access it internally or externally. So again, it's saying, well, actually, we're not just going to build a system that does the same old thing. We're going to think about what data does it need to handle? How is it going to be the right amount for the right purposes? And can we prove that we've thought about that while procuring or building the system? So this is a key area, again, of accountability and governance that you can look at now. If you're thinking of building or buying a new system, thinking of changing a process or changing a supplier of your CRM, it would be a shame to buy a system now that would be redundant in 18 months' time because it won't deliver the compliance that you need with the new GDPR coming into force. So we would certainly recommend looking at current procurements or planned procurements with the GDPR in mind. Okay, so now we're going to look at information management and start with just clarifying what the definition of personal data is within the GDPR. And again, the main point here is to highlight that it's a very broad definition. It's whether someone can clearly be identified or could be identifiable from the data, whether directly or indirectly, and it gives examples of what it could include. And you can see the big long list is actually trying to say it covers most things. An email address, a small bit of information, an ID code, a national insurance number, because actually even on its own it might not identify you, but it can be used to identify you. It's really trying to say that the smallest bits of information can have a value like never before, and we must recognize that when we're considering how we manage personal information. The regulation goes on to say, well, actually, how do you consider if something is identifiable? It's a judgment. What are the likely means that someone would use to try and pinpoint or put together bits of information to identify someone? In the day and age when you can Google small bits of information and start to put together a profile or find out previous work addresses, it's saying the smallest bit of information could be deemed as personal data. And actually that's happening now. If you look at the Dean Street Clinic breach from a couple of years ago, when they inadvertently exposed 731 email addresses while distributing their monthly newsletter. This was an HIV clinic, meaning that if you saw someone's email address on that distribution list, you might infer that they had HIV. And the fact the clinic served a small geographical area meant that actually putting those things together meant those email addresses were really valuable and could have exposed people's HIV status. So the organisation was fined £180,000 for exposing just those email addresses. So it's quite a watershed case and really reinforces why the GDPR is being very clear that actually the definition of personal data is pretty broad in this day and age. What's valuable to people, what could affect their privacy, could be the smallest bit of information. So with that in mind, the question is, do we know what information we've got? Do we really understand what information we're collecting? Do we know who is collecting it? Is it yourselves? Is it your volunteers? Are you getting it from a supplier, a third party? How are you collecting it? What methods and means are you using? Is it all over the phone? Is it all paper application forms? Is it online? We've also got to be mindful of not just the obvious direct information we're collecting, but are we getting indirect data, either from an external source or particularly online? Are we generating or obtaining data that shows people's activities? Is it from their online activities and movements? Is it data you can derive from other data sets? Are you using algorithms or judgments to generate judgments about individuals' propensity to donate or their ability to pay, where they live or what they like? All that information is personal data. And the ICO is very clear that the thing we can all do today is start thinking about an information audit. To know what data we have, where it is, and really understand it is going to be critical as we start to look at then the right measures to protect that data with the GDPR in mind. Really starting to understand why information is being collected. And it sounds a simple question, but actually really understanding the purposes for which information is being collected is critical, because if you know the purpose, you can then get a good sense of how it will be used, who it will be shared with, whether that's internally or externally, what the effect on individuals is of that collection and use and sharing of information. And it's really important to understand those purposes, because once you understand that, you can get a sense of, well, what is the lawful basis that justifies that collection and use of information? And this is really important because that justification ties directly to individuals' rights. If someone has a right to object or withdraw their consent or delete the data, it will very much depend on whether you've got to follow through with those, whether they actually have that power or not. If it's based on their agreement and they're withdrawing their agreement, then clearly you've got to adhere to that. If, however, you're not relying on consent, it's some other legal power that justifies it, then you quite rightly should continue to process and collect that data regardless of how much someone might complain or object. So for example, I might get quite annoyed that my employer tells HMRC each month how much I've earned, and then they will deduct tax from me. That's taking a financial hit out of my pocket every month. It's very distressing. But if I complain or object, it doesn't really matter. It's a legal responsibility for them to do it, but the employer has to understand what is that power, what is that compulsion, and that it is based on that compulsion, not on the individual's consent to do that disclosure. So really understanding what you're collecting information for, what justifies it, is going to be really important with the GDPR. So consent, is clearly one of the ways that justifies the collection and use of information. And the clarity that the GDPR brings is welcome in clarifying just how higher threshold it is to obtain consent under the GDPR. It's got to be, as that definition says there, freely given. There has to be a genuine choice about whether they agree or not. It has to be specific. It has to really relate to some clear purpose. They have to be informed and give an unambiguous indication of their wishes. There should be no doubt that they have clearly agreed, and there should be a clear action by them, a clear statement, something that confirms that they do agree to you collecting and using their information in the ways you've outlined. Now, consent has been a hot topic very recently when it comes to fundraising and direct marketing and the whole questions around opt-in and opt-out. But the GDPR is pretty much laying it on the line there and saying, look, there should be no ambiguity. You should clearly know what they're agreeing to. If there's any doubt or if they can question or query how you've collected it, then I can't see how that could be unambiguous. Especially when the GDPR gives us some further guidance about what consent means. It's highlighting that it can be collected electronically or verbally, that it can include a tick box or a technical settings, some other action that clearly indicates their agreement, but it cannot include silence, pre-tick boxes, or inactivity. That is not going to constitute consent. So again, that's another example of where the best practice at the moment is actually going to be put in black and white in the law. So there should be no issue for those of you who are out there following good practice and best practice already. The GDPR just really confirms that that is the way to do things when it comes to collecting consent. The GDPR also highlights that you've got to be able to demonstrate that the person has consented, so records and audit trails of consent and proof of consent is going to become more important. Individuals, as I say, have a right to withdraw their consent at any time, so knowing which activities rely on that consent or don't is going to be very important. And the GDPR makes clear that it won't be consent if the individual had no genuine or free choice, or is unable to withdraw their consent without some harm towards them. So this again is a good example with human resources, when people sign contracts and it says, well, by signing this contract you agree to us processing your data and doing things with your information. Well, is that genuinely freely given choice? It's not. It's saying you've got to do it to be an employee. What that really means is there's probably another basis on which you should collect and use employee data, because you've got to collect it. You've got to collect it to run the HR service, to administer them as a staff member, to provide a safe, secure working environment for other colleagues. There'll be another basis that justifies your collection and use of HR data that's not consent. So consent, the threshold and the clarity is going to be much more important with the GDPR. Understanding whether there's another basis on which you can collect or use information is important, such as legitimate interest. Legitimate interest exists in the current Data Protection Act and it's still in the GDPR. So understanding whether you can say it's in your legitimate interest, that you need to collect and use the information, and that you've shown that you recognise it's a balance between your interests and the individual's interests, and documented that you've understood it's a balance and you've weighed up the different interests and you're confident about why it's in your legitimate interest to collect and use the information. So again, having that thought through, documented, understood is what the GDPR is going to require. So it's about looking at the different purposes for which you collect information and getting clarity on where the information is and what the lawful basis is behind your collection and use of it. Do you need consent? And if you do, what quality of consent do you currently hold? Is it to the GDPR standard? Probably not. Is it to the Data Protection Act current directive standard? Hopefully. But starting to get a sense of, have we got some data where the consent isn't really up to scratch, and whether we're going to have to go and seek updated consent will be a very important thing to take on board now. There might be times when you could rely on your legitimate interests. The question is, do you want to use that? Are you confident in doing that? There will be some times when you should rely on your legitimate interests. Sending thank you letters, doing administrative tasks are clearly in your interests and in the expectations of the individual. So that's a clear basis for collecting and using that information. Or might there be, as I said, legal obligations, so whether it's gift aid or health and safety at work, whatever it might be, there may be legal obligations that justify your collection and use of information. But having that sense of what's underpinning it is what's important going forward with the GDPR. Another area when it comes to information management and doing your information audit is to really get a sense of whether you're collecting and using data on children. So currently there's no issue, no question about different sets of data based on age. That changes with the GDPR. It says that children should have special protection of their data, particularly when it comes to marketing, social media profiles and platforms. It's essentially saying that, you know, we need to understand if we are engaging children, people under 13 in such activities, and if we do, be very careful about when and how we use their information. So even just getting a sense of that you're doing that and thinking about that is going to be important from now, and getting a sense of what the key issues are and what it's really used for, whether there's parental oversight and parental proof of consent, clarity on how you articulate the fair processing statements so the children understand if they are signing up to services, if they are looking to receive marketing, they really understand it in language they can understand. That's the sort of thing that the GDPR is requiring. The GDPR also brings in a definition for pseudonymization. So really that's the way to think of the activity of splitting out data so it can be no longer attributed to a certain individual to protect really the information. This is saying, well, actually some of the things we need to do with personal information don't actually have to be personally identifiable. You don't care if it's Gary Shipsey who's got certain characteristics. You're trying to do bigger analytics of trends and analysis. So if you split out the element that keeps the data personal, that's a good thing. You're protecting the data. As long as you keep the sources separate so it can't be joined together, that's a potential way to reduce risk in data being exposed or misused while still being able to use that valuable data for other activities. The GDPR also includes a definition for profiling, which I've summarized up above. And again, this is important because individuals should know about the fact that you are undertaking profiling of them if you are, and be aware of it so they can enforce their rights or object or understand it should they have any concerns. This is particularly, I guess, an issue for charities and wealth screening, wealth prospecting, those sort of activities where you are evaluating certain aspects of an individual to understand or predict their propensity to donate or their interests. If that is an algorithm that's doing that and making judgments on on individuals, then they need to be much more aware of that, and there needs to be clarity on how that's being done, how that's being delivered. So that's a quick overview of the sort of management information issues, and it's, as I said, really understanding your information, so really have a clear picture on what is your justification for collecting and using it. And the need to do that is there because when it comes to individuals' rights, you've got to tell people an awful lot more information about who you are and what you want to do with their information. So this is the building on the current obligation to put fair processing notices when you collect data and to have privacy policies to explain what you're doing and why you're doing it. This builds on that and lists far more things that you've got to be willing and able to articulate to individuals. And you'll see it's a lot of what we've just been talking about, clarity on the purpose for which you process information and the legal basis behind that. If you're using and relying on legitimate interests, what they are and how you judge that they're in your interest without harming the individual. So those two are really critical, and the detail behind that is going to be important. But building onto that, there's a whole further list of things that the GDPR requires, how long you're going to keep the information for. So that's really interesting when you look at record retention and the need for real record retention and disposal schedules to define how long you keep personal information for and why, and also how long you think consent will last. So you'll say, well, we'll keep it for as long as we think the consent's valid, and we think that's likely to be a set period and why you think it's a certain period. Having to tell people where data comes from, if it comes from other sources and external sources. Clarifying whether things are a legal requirement or a contractual requirement and what the implications are of not providing it. And as I said, the existence of automated decision making, if that's the sort of thing, and profiling that you're doing with the personal data. So a lot more detail required, and the GDPR is clear that you've got to give that to people at the time you obtain their data if you're getting it directly from them. So the ICO's updated code of practice on transparency notices was released in October and really talks about all this in great detail and references the GDPR and highlights that really it's about fairness. Underneath it all, it's about, do people really understand the things that are going to happen to their data, and are you being open with them about the things that they might not expect or anticipate? Are those things very prominent, and the more detail is in the privacy notice, rather than sometimes it can happen now that it's ran the other way, that the really interesting stuff about what's going to happen to their data is either not published at all anywhere, or it's buried in a privacy notice somewhere that very few people will see. And what people get up front is a very bland and generic fair processing statement that doesn't really tell them a huge amount. So this is saying actually that needs to be really rethought and considered. Part of the RSPCA and British Heart Foundation finds focused on that issue. You know, how clear were the fair processing statements when people gave over their data? Did they understand that they were signing up to well screening and the reciprocate scheme and data and telematching? And the ICO concluded that they didn't. So this transparency piece and fair processing, you know, is actually a key element of the GDPR, and it relies on you understanding a lot more about your data. So that's one clear right that builds on what we've got at the moment. We also have subject access, so that's the current right that all individuals have, and that's pretty similar to what we've got now. But it does say that actually rather than it be £10, it's actually free, so you can't charge people for making subject access requests. Rather than having 40 days, you've only got a month. And if they make a request electronically, then you should give an electronic response back. And again, this is about empowering individuals to be able to access and understand what's happening to their information. And you know, the best practice is being able to provide secure sort of online self-service, so people can log in and access their information. That might not be suitable for everyone, but you can see the potential benefits of rather than dealing with individual requests as and when they come in, just enabling individuals to have a portal that they can log on to, see their data, download it if they want to. That's certainly what the GDPR is looking towards as best practice. And building on that is the right to data portability. So that's about the fact that people can not only see their information, they can actually ask for their own data to use for their own purposes. About actually having, you know, machine readable data, CSV format data, where for free of charge they can take that data and use it for their own ends. So this is where, you know, currently banks are very forward in this. They enable you to log on, download the data into a raw format that you can then use on a spreadsheet. This is about, in theory, it's about being able to take data as a consumer and put it into price comparison websites and get a better deal. That's the sort of rationale behind it. It is only for data that the individual has provided to you or generated as part of their use of their service with you. Only where the processing is based on consent or a contract. So again, another example of when knowing the legal basis behind it is really important, about whether you would or wouldn't have to respond to a request for data portability. And it's for automated information, so it's not for handwritten paper information, it's for electronic automated data. But you can see it's part of building on subject access to say actually I should have a right to manage my data. I know data is valuable and I should be able to manage that as a consumer and a service user. Another right that exists at the moment is the right to object to direct marketing, and that's also in the GDPR. There's also the right to object to any activity and processing based on legitimate interests. So again, clarifying, is it consent? Is it legitimate interest? Is it a lawful obligation that justifies your collection and use of data is very important, because if it is legitimate interest, they can object and articulate why they think you've got the balance wrong, that you're actually harming their interests, and you've got to stop using the data if you are unable to demonstrate a compelling grounds to push back their objection and say, actually, no, we think we need to do it, we believe the balance is right. So the right to object is there, and again, more people will be more aware of this and may want to use their rights as the GDPR comes into force. Another right that got a lot of publicity when the GDPR was being discussed was the right to be forgotten, or the right of erasure. And again, this is about saying if organizations really don't need information any longer, it's out of date, it has no value, there's no basis for them keeping it, they should be able to say to you, get rid of it. As it says there, I've highlighted some of the key reasons why someone might say, get rid of my data. They might say that it's no longer necessary for the reason I gave it to you originally. I've withdrawn my consent and you've got no other grounds for keeping it or using it. Or they've objected on legitimate interest grounds and said, yeah, actually, you're harming my interests and my privacy rights. So again, you can see the importance of being able to push back against those objections and say, actually, no, we do need it. You might not think we need it, but we know there's a legal requirement to keep it. Or actually, you might say you're withdrawing your consent, but that processing of your data isn't based on your consent. It's based on another law. It's based on our legitimate interests. And we can argue and articulate what those legitimate interests are. There's also rights with regards to automated decision making and profiling. This is really saying that a decision that really affects an individual should not be based solely on automated processing without some input by an individual. And it's about assuring that profiling and automation is done with certain safeguards in place, and it's the key sort of things of being fair and transparent and having appropriate algorithms that do the right job, having measures to deal with inaccuracies, and making sure the data is secure. So none of this is saying you can't do things, but it's saying if you're going to do them, take responsibility for doing them and understand them and be able to articulate them to anyone who may ask. So hopefully we're 3/4 of the way through, and we've looked at obligations and accountability at the highest level. We've looked at understanding our data and really getting to the bottom of what data we collect and on what basis. And we've seen why that's so important, because actually a lot of it ties through to the increased individual rights that everyone will have when the GDPR comes into force in May 2018. The last section is looking at information security and risk, and one of the big areas of change is on reporting breaches to the regulator, to the Information Commissioner. At the moment, it's a bit of a carrot and stick approach from the Information Commissioner. They say, well, look, we'll treat you better if you are upfront and proactively tell us about breaches. We won't fine you as much. We'll recognise that you've been open and transparent with us. But there's no legal compulsion on having to tell the Information Commissioner about breaches. The GDPR changes that and says that you've got to tell the ICO within 3 days of a breach if that breach is likely to result in a risk to their person's rights and freedoms and privacy expectations. You've got to tell the individual themselves directly if the breach is likely to result in a high risk to those rights and freedoms, so identity theft or fraud or exposure of their medical status, for example. The issue to take away from today is about raising staff awareness about what does a breach look like, how should they be reported internally, how are they escalated, how are they assessed, about whether they should or shouldn't be reported to anyone. It's about cultural change. Human nature is to want to protect yourself and try and deal with an issue if you've lost a memory stick or lost a laptop, thinking you will find it and put it right yourself. But it's about overcoming that and saying to staff, well, we need to know straight away. If the first we hear of it is when the Information Commissioner's on the phone, or when someone from a newspaper is calling up that they've got someone's handed over this data, we're on the back foot and we don't look good. We need to be on the front foot, showing that we're managing it. It's about a cultural thing, that people aren't going to be immediately penalised for highlighting a breach. It's going to be part of a process to try and deal with the immediate risks that are faced. One of the reassuring things about the GDPR is that the security requirements, the current Principle 7 requirements, largely stay the same. It might not be easy to recognise this because some of this detail is tucked away towards the back of the current Data Protection Act. But actually, a lot of it is very similar. It's about saying you've got to keep up to date with the state of the art, where the current standards are when it comes to information security and encryption. And you can always weigh that up against the cost of implementing any measures. So it's not saying one size fits all, and we know that MI5 level encryption won't work for everyone. That's quite right. But it's got to be based on a judgment. It's got to be based on the nature of the information and the scope and the context and what you're processing it for. It's got to be based on an assessment of risk. How likely is something to happen? How severe would be the impact on individuals? And you've got to put appropriate measures in place. So it's saying a lot of what the current law is saying. It's about saying when you're assessing the appropriate security, you've got to look at all the potential things that could have an impact, not just loss, but accidental destruction or alteration or disclosure of the personal information, whether that's when it's being shared or transmitted, whether it's in storage or any other use, so whatever activity happens. So while a lot of that, the requirements are the same, again, the difference all the way through this is about the evidence. So for example, if you look at recital 87, it says if there's a breach, then you've got to clarify whether the appropriate technical measures and organizational measures have been implemented. Are they actually in place? So great, someone loses a laptop or a memory stick, you think it's encrypted, so there should be no issue. Okay, well, prove that laptop, that actual staff laptop, prove that that actual memory stick had encryption, what standard of encryption, when was it implemented? Evidence and prove that that is the case, not just a hope that the policy says it should have happened, or there's nothing else to back up your assertion that there's actually not a serious breach because the encryption is working and in place. And the overall, some of the headline messages that come through about the fines going up are true. This is about the GDPR saying to the likes of Google and Facebook that, personal data is an important asset. We want you to pay attention. So the likes of Google and Facebook will pay great attention to a fine that could be up to 4% of their worldwide turnover for a year, or 20 million euros, whichever is greater. For a lot of that does reflect how valuable an asset personal information is in the 21st century, and as we sit here now. But really, for most people, the fines are secondary issue. It's the immediate impact on trust, on your values, on your integrity, on the belief that people have that you understand and recognize the importance of the information that they are entrusting you with. And that's the thing that can really harm you far quicker than a regulator getting around to fining you at some point. The other impact that may come with the GDPR is the fact that individuals can directly claim compensation for non-material harm. So the current law, you can only claim compensation if you can show financial loss as well as any emotional distress or harm. And that's quite difficult to do. A lot of breaches are about breaching personal privacy and information without an actual financial impact. The GDPR removes that barrier and says actually individuals should be able to claim compensation if their very sensitive personal information has been exposed. If those people at the Dean Street Clinic, if their HIV status has been exposed because of a breach, their life has been fundamentally changed, they should be able to make a claim and demonstrate how much of an impact that's had on the rest of their life. So that's the change that's coming. So we've sort of concluded this section on information security and risk. There's obviously a lot more detail we could talk about. One thing I did want to pull through was for many of you who've joined us, charities or fundraising, to look at the fines just before Christmas for the RSPCA and the British Heart Foundation. The fact that they were 10% of the actual figure that they could have been fined. The ICO showed discretion, knowing that charities, there's a couple of more charities that are going to be under scrutiny. I bring them up because actually they're a good example of these issues being actually live now. So the GDPR is coming, but the issue of understanding the lawful basis under which you're collecting and using information, the clarity on the purposes you want to use it for, the clarity that you need to get across to people when collecting their information are at the heart of these two fines. You know, the ICO doesn't mince their words in the fines, and it says that fundamental rights have been breached for millions of people. You know, we can't get away from that. The issues that the organisations were involved in, the processing that was they were involved in, related to not just one topic, it was three issues. The combined effect is why the fines would have been so high. And if we look at, you know, we look at, well, what actually do we need to understand to undertake direct marketing? It could be HR, it could be service delivery, but in this case it was direct marketing, it was fundraising, and the three pillars are critical. We've got to understand our purposes, we've got to understand the lawful basis behind doing these activities, and we've got to really be fair and transparent with people when we want to use their information. And we've also got to recognise that there are other activities, other purposes that aren't the core purpose that we deliver, but they are purposes, and we need to understand which ones fall into which category, which are purely administrative, which are actually direct marketing. That makes a big difference about whether you do or don't need consent often. We've also got to recognise that we use third-party suppliers for a lot of activities, and that's fine, but we've got to recognise when they're involved. Is there a two-way flow of information between yourselves and the third party, where they're providing a service on receiving data from you, providing a service and giving it back to you? Or is there a one-way flow of information? They are collecting data from you, collecting data for you, or are they actually supplying a service once and then there's no flow of data back? But understanding these issues and how there is a clear justification for collecting and using data is more important than ever. And if we just look at just trying to summarize some of this, if we look at those three different purposes and say, well, actually, were people told that's what their data was going to be used for? Would people really realistically expect data sharing to be going on or well screening to be going on if they were told that, you know, all you're giving your data over for is fundraising, or so we can tell you more about the difference you're making? Probably not. I mean, the ICO concluded and said, look, these were the statements that were in place, and we don't believe that those fair processing statements did a good enough job. They didn't articulate these other activities that people would probably not expect to be going on. The ICO concluded both ought to have reasonably understood that people would be unlikely to infer from those generic statements that their data would be processed for well screening or, you know, shared so broadly. And by failing to explain that, you know, they deprived people of control. They couldn't make informed decisions about whether to provide their data. They couldn't actually enact their rights or be clear about their agreement to what they wanted to happen to their data. And by doing that, by not being clear, well, they breached Principle 2 of the Act as well, because actually the purpose for which the data was collected, which was administering the donation, was not compatible with other purposes because they weren't clearly articulated. So what I'm trying to highlight here is that, you know, the ICO is looking at this stuff now, and that's well before the GDPR comes into force. The key messages of the GDPR are going to be the same, the key principles, but about really understanding and evidence it is important now, and getting started to look at these things now, ready for GDPR, is the key message. And if we look at lawfulness, just to finish this bit, we look at actually, did the organisation need consent to undertake these activities? The fines were pretty clear on data sharing and data matching. There's you know, debate around whether you need individuals' agreement to do well screening. It very much depends on what type of well screening, and you know, you can imagine there's a big difference between really privacy intrusive building up of a profile of someone based on lots and lots of data, making judgments about them, targeting them in different ways because of that, all without their knowledge or agreement. That's quite different to doing some segmentation based on postcode, where it's not as intrusive and it's unlikely to need an individual's consent. In these cases, the consent wasn't obtained, and the question about whether you can use legitimate interest potentially needs to be thought through as well. So I really hope that session has been useful. We do have a GDPR stress test that we've put together. If anyone would like a copy of that, I'm going to put up a poll in a moment for people to register their interest if they'd like us to send them a copy and have a chat with them about our stress test, and also or a free policy review subject to availability. We will look at the current policy, the current privacy statements, and give you some feedback and come and meet with you and discuss what we would recommend. We do provide two main services. We have our Data Protection Officer Support Service, where we support your data protection lead in preparing for the GDPR and assessing your current compliance across a range of different services and activities, whether it's an audit or training, template policies, coming to our seminars, occasional advice, whatever it may be. We'll make sure that your data protection lead has the skills and knowledge to deliver compliance. For the fundraisers out there, we've got a tailored service that really gives fundraisers the training and awareness on these key issues of purpose and lawfulness and transparency to make sure they can continue generating income and for their beneficiaries in these these really unprecedented times of scrutiny and great change. There's always a way to manage these things. It's about the level of understanding and detail that's the critical thing. Like I said, the ICO has flagged up that the current law is a pretty good starting point to get ready for the GDPR. If you're currently up to date with the best practice in the current law, then step up to GDPR shouldn't be a big a step. But it's about really starting to look at your current services, your projects, your current approach to handling information, and then once you've had a look and reviewed it, being really confident in articulating that to whoever might ask, whether it's the Information Commissioner, a service user, the Daily Mail, whoever it might be, confidently understanding how and why you're collecting information, what you're using it for, and what the basis is behind it. So I really hope that session's been useful. If people would like to hear from us and get a copy of the stress test, please tick the screen now, and we can make a follow-up call and start talking to you about the what we've got and how we might be able to help you. It's a short period of time to get across a lot of information, and I hope it's been useful. We will be having a recording of the event, of the webinar, and we will be able to circulate a link to that after the event as well. Thank you for responding to the poll. We are Protecture, and as I said, we're happy to receive your questions and queries, talk to you about our stress test and our free review. We look forward to working with you and hearing from you about what issues you may have. And thank you very much.